be warned. I've been told this should be 10 minutes. Lawyers don't do 10 minutes. But I shall be as quick as I can, and I will rush it. So, I give the game away with the title, which is Potential Unfulfilled. So far, there's still time, but I think there are things which should have been done, which haven't been done. Can I pick up from the final bullet point that Sheila had on her final slide this morning, which was legislation alone is not the solution. That is self-evidently the case, but without legislation, the owners and keepers of animals cannot be held publicly accountable for the way in which they look after them, and most particularly mistreat them. I'd also say, going back to Sheila's presentation and the Gandhi quotation about society in general, that the level of legislation reflects society's standards. It's a collective view of where we are so far as the protection of animals is concerned. And thirdly, legislation, particularly where animals are being used commercially, legislation protects those who are doing it properly off their own backs, on their own initiative. Because without basic standards, those who are not doing it properly can clearly undermine them. So legislation is essential. And as you've already seen, 3 different pieces of legislation follow much the same format. There are slight differences. I have to say, there seems to be a large Scottish contingent down here doing missionary work today. But obviously I'm English, but I have to say that where there are differences, I think the Scottish Act is better. Scotland and England and Wales, the legislation passed in 2006. Northern Ireland come along slightly later, but the same format. And the purpose of this legislation was far-reaching. First of all, it was meant to provide an up-to-date, comprehensive and durable legislative framework. It was intended to promote responsible animal ownership and keeping. It was to extend and clarify legally who was actually responsible for the welfare of animals, to restate what used to be called the offence of cruelty, now the offence of causing unnecessary suffering, to extend welfare requirements, particularly to companion animals, which was the large group of animals for which there was no welfare provision previously in the so-called duty of care, to provide enabling powers, that is to say, to give ministers the power to introduce by regulation new legislative provisions, which are quicker, doesn't have to go through the whole parliamentary process, to provide for early intervention where there was a problem, rather than waiting until the animal was in such a bad state that they were clearly could be shown beyond reasonable doubt to be suffering, and to improve enforcement. The issues, as I see them, are first of all visibility and impact of the legislation, issues around unnecessary suffering, issues around the duty of care, secondary legislation, enforcement, devolution. And as Chris has said, some of this is being looked at, but not everything across the UK. So far as visibility and impact is concerned, have any of you seen this leaflet? Yes, Rebecca, one would expect you to have seen it. No brownie voice. Rebecca is the person who has it in the DEFRA archive. When the legislation first came out, this leaflet was produced in hard form by DEFRA. If anybody has a copy and cares to take it along to flog it or the Antiques Roadshow, it's probably worth quite a lot now because it is a collector's item. And part of the problem here, and we'll see it exactly the same when we get to the codes of practice, is there's all this information is available on the web. But, and as somebody said this morning, it can be accessed with 2 clicks. But the person has to have the initiative and the impetus to go and look up the information. The idea, it seemed to me, when this leaflet was first produced, was that it would be freely available at pet shops, at pet food shops, anywhere where people involved with animals would be involved, this leaflet would be available. It's never, I don't think it was ever printed. I think they had a few monks who sort of copied it out in medieval longhand. So, and the PDSA pause report has backed this up, that people are not aware of the Animal Welfare Act. We all are, and I think we get a false impression of this, because we are all aware of it, and we sort of banter about the Animal Welfare Act and the AWA and all this stuff. But the people that it's needed to get to, it simply isn't getting to. Unnecessary suffering, I don't think there was a problem with unnecessary suffering, apart from the convoluted language in the legislation. What Parliament intended to do, and did, was to restate the old offence of cruelty, incorporating the case law as it was in 2006, because they didn't want to change the law as it was. Some of that case law goes back to 1889, I have to say. Good case law, but it means that the provision is convoluted and doesn't make any sense, except to the half dozen of people who are aware that it's meant to incorporate the case law. And I think what has happened, it's certainly come up at the EFRA hearings, that and in the written evidence to EFRA, that there is a problem with the unnecessary suffering test. Certainly, there can be a problem with what actually constitutes suffering. When is that threshold met? Necessity can be a problem. The actual offence itself, I think what people misunderstand is that the duty of care was intended to complement the offence of cruelty. The problem was that cruelty was retrospective. You had to wait until the animal had actually suffered, and suffered to such an extent that you could demonstrate beyond reasonable doubt to a court that it had suffered. And as most incidents of cruelty arise from negligence, where an animal's condition deteriorates over a period of time, it meant that enforcement agencies ended up in the absurd situation where if the owner didn't cooperate, they had to stand around actually waiting for the animal's condition to deteriorate to such an extent that they felt that they could get a prosecution. The duty of care was intended to provide the opportunity for earlier intervention to put the situation right. I think there's a need for the courts to have this explained to them. The duty of care as such, you're familiar with it, but there's a problem here. And the problem here is, first of all, good practice. What exactly is good practice? And I'll come to that shortly. Oh, God, it's gone amber, so I'll put that bit of paper over there. That's what I bought that for. This is important. Now, the relevant circumstances include any lawful purpose for which the animal is kept, any lawful activity undertaken in relation to an animal. Now, to demonstrate to you what a nonsense this is, we talk about guidance, we talk about good practice. What is the one thing that the public may have heard of in terms of choosing a puppy? What do they have to see? The bitch. They have to see the bitch. That is the guidance. That is DEFRA's guidance. It's on the DEFRA website. There is no requirement here for the bitch to be seen, and let's take let's take a random example. Dogs for Us. Okay? A perfectly legal operation. A puppy supermarket operating in Leeds and Salford. Licensed by the local authority, operating quite lawfully, has a range of puppies in stock at any time, a large number, none of which will have the mother with it. Nothing can be done about that because what they are doing is perfectly lawful because they're licensed to do it, notwithstanding that it goes against all the guidance, including government guidance. It is a complete and utter nonsense. Same issue with good practice. The idea was that there was going to be a range of codes and these were going to be representative of good practice. Now, important point here that has already been mentioned. There is a wealth of information out there. Everybody with an interest in this has their guidance, has their advice. And I would suggest that that is the problem. It's too disparate. What is important, what is significant about this advice is it is government advice. This is where the courts will start. Now, we all know that all the governments ran out of money, so this project rather ran into the sand. What there is, however, has already been demonstrated, is a range of other advice produced by various bodies. It seems to me that what we need is a scheme where this is relevant advice is officially nominated as good practice so far as the legislation is concerned. Oh, it's flashing now. Secondary legislation. The idea was that a whole network of secondary legislation would be built up. In 10 years, this is it. It is quite frankly pathetic. England has microchipping, dog microchipping, circuses, greyhounds. Wales has microchipping, electronic collars, dog breeding. Scotland has microchipping and animal dealers. Now, we know that things hopefully are beginning to move, but it's taken 10 years to do it. That is not fast enough. Enforcement, these two gents will talk more about it. Just to mention that the real lacuna in this legislation is that local authorities theoretically have a central role in enforcement. They are permitted to appoint inspectors under the Act. The weakness is that that power is entirely discretionary. Many authorities have not appointed inspectors under the Act, and those that have, many of them are withdrawing because of financial constraints. RSPCS, SPCA, sanctions, the sanction, what exactly is the punishment meant to prove? What is it meant to do? Fines tend to be minimal, largely because most of these people, their lives are in chaos anyway, they don't have much money, and putting them into prison for 3 months just further messes up an already messed up life. We need to think about what exactly the sanction should be, and also these court orders. The whole range of disqualification orders which are available to the courts and which enforcement agencies will generally say that is the reason why they're prosecuting. The problem here is that there is no central register, although we were told there would be. There is no central register of those who've got enforcement orders, disqualification orders made against them. It is complete luck whether anybody knows if a disqualification order is broken. And we need the courts to get to further training in the courts. Finally, devolution. Clearly, it would be a nonsense for everybody to have exactly the same legislation. If you want everybody to have the same legislation, you don't devolve power. So it is inevitable that different parts of the UK are going to have different laws. But it does seem to me that there is a role for parliamentarians to talk to one another here. Clearly, ministers do, and more particularly officials do, as between different parts of the United Kingdom. But I think there's a role for the all-party parliamentary group, for the equivalent cross-party group in the Scottish Parliament. Northern Irish Assembly and the Welsh Assembly don't have quite an animal welfare organisation group, but there needs to be some link between backbench politicians talking to one another across the 4 legislative assemblies. I'll stop there.